Losing your job is never easy, but being fired for the wrong reasons can be illegal. If you suspect you were wrongfully terminated, it's critical to understand your rights, what qualifies as wrongful termination, and what steps you can take next. Let's break it down. First, what is wrongful termination? Wrongful termination occurs when an employer fires an employee for reasons that violate the law or public policy. In California, most employment is at will, which means employers can let you go at any time with or without cause. But that doesn't give them a free pass to fire you for illegal reasons. Here are some examples of wrongful termination: being fired for reporting harassment, discrimination, or unsafe work conditions; termination due to race, gender, age, religion, disability, sexual orientation, or other protected categories; getting fired after taking protected medical or family leave under laws like FMLA or CFRA; retaliation for whistleblowing, such as reporting fraud or labor law violations; termination that violates the terms of an employment contract. It's not just about fairness, it's about legality. Even if your termination felt unfair, it only qualifies as wrongful if it violated specific legal protections. That's why documentation is so important. So what should you do if you think your firing was unlawful? Step 1. Gather evidence. Start by collecting any documents or communications related to your employment and termination. That includes emails, performance reviews, your employment contract, if you had one, disciplinary records, and your termination notice. Also, make notes about anything that happened before your firing, especially if you recently made a complaint, requested leave, or experienced discriminatory behavior. You'll want to show a timeline that connects your protected activity with the termination. Step 2, request a written reason for termination. California law doesn't require employers to give a written reason for firing you, but you can still ask. If they provide a reason, compare it with your records. Was it performance related, downsizing, or something that contradicts your recent reviews? Inconsistencies can support your claim. Step 3, consider filing a complaint. If you believe your termination violated federal or California law, you can file a complaint with the appropriate agency. For example, the Equal Employment Opportunity Commission, EEOC, handles cases of discrimination or retaliation based on protected characteristics. The California Civil Rights Department, CRD, handles similar complaints under state law. The U.S. Department of Labor handles some wage-related violations. These agencies can investigate your case and, if needed, issue a right to sue letter so you can pursue legal action. Step 4, speak to an employment attorney. Wrongful termination cases can be complex, and each situation is different. An experienced attorney can evaluate your case, explain your options, and help you recover damages, such as lost wages, emotional distress, and even punitive damages in some cases. If you've signed a severance agreement, do not sign anything until you've reviewed it with legal counsel. You could be giving up important rights. The bottom line is this: being fired doesn't always mean your rights were violated. But if the termination was based on discrimination, retaliation, or a violation of public policy or contract, you may have a legal case. You don't have to face this alone. If you think you've been wrongfully terminated, visit employeelawgroup.com to schedule a confidential consultation. We're here to help you protect your career, your rights, and your future.